existed, over the years. So essentially what has happened here is that if you can't be treated as a publisher but can act as a secondary publisher, that means you're not accountable for any of your actions. That doesn't make a lot of sense because there's something called canons of statutory construction, which I'm sure you are familiar with. But
Yes.
for your audience, there are ways that laws are specifically built. This is how they function, right? A couple of those, for example, are like the absurdity canon. A law can't be absurd. It can't literally be ridiculous. And of course, it can be fixed if it's just a grammatical error. Like, hey, look, you just read it wrong. Or the harmonious canon or the whole text canon, meaning a statute has to make sense as a whole. Okay, so let's think about this. The next section, right after this, allows them to take, quote, any action voluntarily to restrict materials in good faith. Let's just take out everything else but that, right? Let's make this real simple for them. If they're acting in good faith, they can restrict harmful materials. That's what it says. But let me ask you something. I know this is going to be a really tough question here, but restricting materials, isn't that a publisher action?
You're asking me. Not only when they restrict materials, but when they put a label on it that says that it's false, because a court should take judicial notice of the fact that fact means objective fact and opinion is totally different. There you go.
Yes, it's publishing. Making any decision on what content is allowed, modified, manipulated, advanced, developed, created, anything. It's all publishing, all of it. So everything that is allowed in the next portion of the statute, it's already protected under the first portion of the statute. Well, that's not harmonious, right? It's conflicting. It makes it duplicative. And you look at it and you go, wait a second, so there's something wrong here. And well, that's because it doesn't protect any publishing conduct. It's just like they drove past. So that's what 230C1 does. It's as if they drove past the accident. They didn't do anything. It doesn't protect them from any of their own content. It prevents them from being treated as somebody else. But when the court screwed that up and read it wrong, they read it so that it protects them from all of their own conduct, which makes no sense with the next portion. So it can't be right. We knew it couldn't be right. We argued it couldn't be right.
Well, that's not harmonious. The way they're interpreting the statute says they can do whatever they want. That's not harmonious with the Constitution.
Well, that not only is absurd, it means that they have unfettered immunity, meaning there's no limits to it. And we said, and now this is on the second run of the Supreme Court, that's where we made the pivot to start going, wait a second, there's a problem here. So let's just say hypothetically, arguendo, that the court's right, that they are allowed to do make any publication decision whatsoever under C1 by itself, right? And that somehow that's not duplicative, okay? We said, well, wait a second. There's still that first portion that describes the legislative motive. What do I mean by that? Well, Section 230 is what's called an affirmative defense, right? And an affirmative defense, an easy one for most people to recognize, is self-defense, right? And in self-defense, somebody is allowed to commit an otherwise unlawful act under certain circumstances, but the burden of proof shifts to the defendant to prove that they are entitled to the government's protections. Sound familiar? Well, that's exactly what Section 230 does. It says that if they acted as a good Samaritan, because it's in quotes, it's right there in the law, it's articulated what Congress's intent was, meaning at the threshold, they have to be good Samaritans. That goes back to the original argument. And we said, wait a second, even if this court's right, they're not, they still have to be good Samaritans, and they weren't being a good Samaritan when they were wiping me out for their own financial gain, which was my entire allegation. And if you consider my allegation to be true and in the most favorable light of me, that's not going to fly. Well, guess what? That's when the courts did something even more bizarre. And it's funny because I describe it as, it's like they took the square peg and they rammed it in the round hole and it kind of fit, right? And then they were kind of like shaving some of the corners off as they were trying to make the rest of the statute fit. And now they literally chopped the thing into pieces just to fit it through the hole. They instead of fixing this, instead of saying, well, wait a second, we did get this grammatically wrong. It doesn't protect what we're saying it protects. It can't be unfettered immunity. They instead said that the legislative intent does not apply to Section 230C1, and that 230C1 allows them to do anything they want to restrain our rights. Holy cow. Now,
And that's where the V and the A publisher really takes hold.
that's what the origin of the mistake, which it caused the misapplication to be unfettered publishing immunity, which rendered the rest of the statute disharmonious. And now, in order to make that fit with Good Samaritan, because it doesn't fit with Good Samaritan, they essentially eviscerated the entire law. They basically said if you shoot somebody secondarily as a property owner, you don't actually have to act in self-defense. It's cool. Your motive doesn't matter.
Oh, that's crazy. That's not
It is.
harmonious.
That's exactly right. And so we took that back. So that's what the Northern District of California court did. Now, that district judge has since recused himself voluntarily out of nowhere. After 5 years, just left.
Well, my understanding is he's almost 90 years old. Is that correct?
Yeah, I believe that, I don't think there's necessarily anything nefarious there.
This brings me back to the problem that I noticed when I was at the Court of Appeal. Who are his law clerks? Because if they're people who hang out on Yahoo and Google and
What if they're
Facebook,
the trolls?
they might be the same trolls that have been attacking me on the article, which I'll post up here. Look, I posted an article that says that talked about good faith in section 2, and that putting a fact check label that says something that you did is false is clearly defamatory under just basic inducement arguments that you would learn in law school, even though most people got that wrong in the bar. But if you induce someone to think that someone's a piece of shit, even though they're not, you're liable if they're not. And that's basically what they're doing by putting a fact check label of saying, this guy's he's a conservative, he supports children, he doesn't believe in genital mutilation, he's a bad person, you shouldn't believe anything he says. And then that goes on CNN, MSNBC, and every other network. That automatically makes you look like, to at least 70% of the people, like you're a liar. Why don't they put opinion check? Clearly it's being done because they want to disparage you. Go ahead.
So, and you brought up the point that I think I sort of was the revelation here is that Good Samaritan doesn't apply if they simply can't be treated as a publisher unilaterally. It's immediate. They don't bring a 230C2 defense. They bring a C1 defense and say, oh, we can't be treated as a publisher even when we are one. And even when you try to apply the motive to their actions, the motive doesn't even apply. And you go, wow, this is a problem. So when we went back to the Ninth Circuit on the second run, we said, none of this makes any sense. It's unconstitutional. Instead of respecting my constitutional rights, the Ninth Circuit relied on procedure and said, well, you advanced the Enigma versus Malwarebytes too late. That started a year and a half ago. Yeah, but it had literally weeks before, I think it was a month and a half before, had been finalized in the Supreme Court, meaning it became law. It was not, it was legitimately in appeal for the whole year and a half back and forth in courts. So it wasn't really usable until it became settled law in the Supreme Court when they affirmed the Ninth Circuit's decision that, oh, you're right. The merits of that, the point of it was that we argued that they didn't act as a Good Samaritan, but we didn't know about Enigma.
Until it was decided.
Exactly.